Well, U.S. agriculture received a big win today as the Supreme Court handed down its ruling in the Sackett versus EPA, with the High Court overturning the Ninth Circuit ruling that was in EPA's favor. Roger McEowen with the Washburn School of Law joins us now for more on this. And Roger, I said in a commercial break, boy, I didn't know we were ever going to see this day. I know the Sacketts bought this property back in 2004. They have been in court battling this ruling since 2007. So give us a little background, a summary on this.
That's right, Suzanne. Good to be with you. Yeah, they bought this property almost 20 years ago, and this was actually their second trip to the U.S. Supreme Court. They had won the previous decision, which said they could actually challenge a pre-enforcement order of the EPA. But they bought this property. It's in northern Idaho, and it's about 100 to 150 yards from Priest Lake, Idaho. And they began backfilling the lot with dirt to prepare for building a home. And EPA told them that their lot was a water of the United States because it was near a ditch that fed into a creek that fed into Priest Lake, which itself was a navigable intrastate water, and therefore the backfilling violated the Clean Water Act. And so EPA said, if you don't quit doing that, we're going to start fining you $40,000 per day that you don't stop. They sued. The trial court granted summary judgment for the EPA, and the Ninth Circuit affirmed, and the U.S. Supreme Court decided to take the case last fall.
So what exactly is the Supreme Court ruling saying?
Well, this is actually a unanimous opinion. There are 5 justices that wrote the primary opinion, but there are other concurring opinions. So it's a unanimous opinion, but for different reasons. And the court said that the term waters in the Clean Water Act refers to geological features only that are streams, oceans, rivers, and lakes, kind of the common sense notion of what Congress meant by the term waters, and to adjacent wetlands. And this is the key, that are indistinguishable from those bodies of water. So if you have a wetland on your property that is in itself indistinguishable from a water of the United States due to a continuous surface connection, then the government has regulatory authority over it. But if it's not, if it doesn't have a continuous surface connection, or if it is distinguishable somehow from a navigable body of water, then there is no federal government jurisdiction over that. So the EPA now will have to establish 2 things. They're going to have to have jurisdiction. They have to establish that the adjacent water body is a relatively permanent body of water that's connected to an interstate navigable water, and that wet area on a farm or a ranch or a lot like this has a continuous surface connection with that water that makes it difficult to determine where the water ends and where the wetland begins.
So, Roger, how soon will this play out? You know, we, of course, have been talking about the EPA's WOTUS rule and waiting to see the Sackett case and how that would go. So now what happens, and how long of a timeline are we looking at for these guys to get back to it and maybe reestablish what this rule says?
Yeah, that's a good point. But the Supreme Court was pretty clear that the Biden administration's WOTUS rule is gone. They said that the EPA's 2023 WOTUS rule is, quote, inconsistent with the text and structure of the Clean Water Act, and that the EPA, quote, has no statutory basis, none. They said no statutory basis to impose a significant nexus test. End quote. So as I read that, that kills the 2023 rule and kicks us back probably to, kicks us back to this opinion in terms of the agencies writing a new rule that will have to be consistent with what the court has said. But that 2023 rule is gone.
So big implications for agriculture with what this is saying, isn't it?
Yeah, it really solidifies the National Water Protection Rule of 2019 as the correct approach. And that's the rule that limited federal jurisdiction to traditional navigable waters and their tributaries. Now, this is the important point for agriculture. Streams and ditches and private waters that don't have a continuous water connection to navigable waters aren't subject to the Clean Water Act. And that's going to remove possible jurisdiction under the Clean Water Act to a lot of ephemeral streams on farms and ranches. I think of western Kansas now in my mind, that most of the time of the year, those are dry streams. They just dry up, and particularly in the plains and in the western states, those will not be subject to regulation according to the Supreme Court now. So big win for ag.
Absolutely. Big changes for sure. Roger, thank you so much. Always appreciate your intake and, of course, your intellect on all of this. Roger McEowen with the Washburn School of Law. Again, we thank him.